start with our first question. It looks like we have about 24 questions this morning, so great turnout. Our first question, I typically read the question and then I'll answer the question. In our CC&Rs, under application of payments, it states all payments received by the association shall be applied first to the principal amount due, including late charges and attorney's fees, and then to interest accrued. Is this recommended for HOAs? It is the opposite of the usual practice of banks and credit card companies. That is true. Well, actually, there's a state law in Arizona that directly addresses this as well. So if you're a condominium, it's A.R.S. 33-1256J. If you're a planned community, it's 33-1807J. And basically what this says under Arizona law is that all payments received on a unit owner's account are applied first to any unpaid assessments, unpaid charges for late payment of those assessments, unpaid reasonable collection fees, and unpaid attorney's fees and costs incurred with respect to those assessments in that order, with any remaining amounts applied next to other unpaid fees such as fines, charges, and monetary penalties, or interest and late charges on, monetary penalties. So, this section is going to be controlling under the law, not the section in your CC&Rs. So, yes, payments should first be applied to assessments, late fees for those assessments, any collection fees that you may have charged by your management company, attorney's fees, and costs in regard to those assessments in that order. And it is unusual because you're right. Usually you pay interest on your mortgage first, your deed of trust first. You pay this on your credit cards. You're paying interest on a monthly basis and maybe not even paying down the principal in some cases. But this is specific to Arizona law. Our legislature passed this for a reason. And they want to make sure that all payments are paid in this order. Okay, next question, number 2. Assume an impending community vote to increase association dues. What best practices should be employed in response to vitriolic misinformation and false written and verbal claims by a minority of residents strongly opposed to the proposal? Further assume the false claims include allegations of dishonesty and fraud on the part of board members. Ooh, that sounds like a difficult situation. Okay, a couple things. Increasing association dues is a necessary evil. Okay, when board members come to me and they say, we haven't raised our dues in 12 years, isn't that great? I'm thinking, I have to take a deep breath because that's not great, because everything else is getting more expensive with inflation. And so you are operating with, the same dollars and everything's costing more. And what does that usually result in? Deferred maintenance, not being able to renovate common areas that need to be renovated and upgraded and improved. And so having increases is normal. In fact, every association should be having an increase, even a small increase every year. Okay, so what do you do here in the situation where you've got a group that's really upset about an increase? I think it's time for a town hall meeting. You need to get the information out, communicate to your owners why this is necessary. The best way to do that is show them the numbers. Show them what's been happening in 2022 and 2023. And that expenses are continually going up and we can't afford, our expenses unless we raise the dues. And this is the only way we can do it. So have a town hall meeting. If you think people won't be receptive to coming to a town hall meeting, start pumping out information about why this is necessary. Give owners a place to call, to ask questions, to answer, have their questions answered. You're going to have to do a PR campaign to fight this, alternate universe group that is trying to, undermine our ability to function as a business. Okay, next question. Our CC&R is written in 1979 with restrictions on public street parking. CC&R is amended in 2017 concerning an unrelated issue. Did the amendment forfeit our control over street parking? If we rewrite the CC&Rs, can we include the parking restrictions? So I don't know enough about your associations. I don't know if you are HOA. I don't know if your streets are actually dedicated to the public. It looks like they are. So it's hard for me to answer this one. And I also don't know specifically about the amendment to your document. So this one, I think we're going to have to sidebar on and take a look at. We'll see if the new law applies to you or not, and if you're able to continue regulating on-street parking in your streets. Okay, next question. So for this person, go ahead and email me directly, and send me your CC&Rs and the amendment, and I'll take a look at it for free. Okay, next question. Can an HOA require a homeowner to use a licensed contractor, for instance, in installing solar tubes on their roof? The roofs are maintained by the HOA, or replacing sunscreens. So I'd like to see your CC&Rs as well on this one, but if you are maintaining the roof as an HOA, that's one of your responsibilities. I'm pretty sure that putting solar tubes on the roof could potentially void the warranty for any roof warranty that you may have. So I do think that, having a licensed contractor requiring that, it does not seem unreasonable. Remember, under the law that we can't effectively prohibit somebody from having solar energy devices on their property. So I think there's kind of a balancing factor here. I don't know what you mean by solar tubes, but I'm assuming that that's like a solar energy device that would fall under the law. And, that's not something that, you should just throw that spaghetti up there on the roof and anybody can do it. You need like a licensed and bonded solar company to do that. What about replacing sunscreens? That's probably, I don't know who's responsible for the windows or whatever, but that's probably going to be, their responsibility. And, I don't think we can force them to use a licensed contractor. However, we want it to be aesthetically pleasing, and they probably do need to, seek architectural approval before they do that. You could encourage them, to have somebody who's professional, licensed, and bonded be doing the work. Okay, question number 5. We recently had a special assessment for painting our units. One owner refuses to pay. Our management company says we cannot send this matter to collections unless our CC&Rs say specifically we can do this. Ours say we can collect our monthly assessments and delinquent assessments. So this owner has gotten a freebie, and our management company will do nothing. Is this true, and what are our options? Okay, so we have 2 cheat sheets that I think would be helpful here. One is on collecting assessments, and one is on secrets to collecting assessments. So I don't know. I don't have your CC&Rs, so I don't know. Do your CC&Rs not have something on the ability to levy a special assessment? I'm assuming that's what you're trying to say here. And so most of the people paid it to paint, but there's one person that hasn't. I think you really should encourage your board to escalate this to your attorney. Because even if the contract doesn't, the CC&R, just the contract, doesn't allow for you to, collect this money under the terms of the contract, there's no special assessment section. We might be able to collect this under, another legal doctrine, like they've been unjustly enriched or under quantum merit. So let's take a look at this. I mean, I would at least try. It can't hurt to send a letter saying, hey, you benefited from this, you need to pay for it, and see what the owner's response is. But you should definitely escalate that to your attorney to get an opinion. I don't know how much it is, but typically painting is a couple $1,000s, so it's a lot of money to be out. Okay, next question. Hypothetical. A majority of homeowners decide to have security cameras for common areas removed. 2 months later, a crime occurs that could have been prevented if the cameras had been in place. Who may be held responsible, the association or the homeowners in question? Ooh, really good question. So we have a great cheat sheet that we're sharing with you right now on preventing crime and limiting liability for an association. This is kind of a sticky wicket question because, just because the security cameras were removed, I'm not sure that there's a direct correlation that crime would have been prevented. It maybe would have been filmed, but I'm not sure it would have been prevented unless there's somebody live watching it 24/7 and they could have sent the security guard for your association, there right away if they saw it. Here's what I will say is that, if the homeowners, a majority of the owners are saying we don't want this anymore, and then the board responds by taking the cameras out, there could be some liability for the board, but it's going to be lowered because the homeowners don't want the cameras, right? And we're acting at the will of the homeowners. But there's a case in Arizona, that I think is important. And it talks about the association's board is required to keep the common areas safe and free from crime. So if, we had security cameras in place because there had been a lot of crime in your association, and then we decided to take them out, even though we knew that crime was continuing, under the Martinez versus Woodmar condominiums case, that's problematic in Arizona because we have a duty to keep the common areas safe and free from crime. And in that case, what happened was an association had a security guard that was roaming the association because there was a lot of gang activity in this association. And due to budgetary constraints, they had to get rid of the security guard. And then what happened is the guest of a tenant was shot on the common areas of the association. And the association was sued for not having the security guard anymore. And there was, a lawsuit. It was a reported decision in Arizona. And the insurance company for the association likely paid out, some of the damages for that particular issue. So can there be liability possibly for the association if they knew that there was an issue and they still agreed to remove the cameras because the owners wanted them removed? I mean, that comes into a situation we really want to get your attorney involved to talk about what is liability here. And is it a good idea to listen to the owners when we really have fiduciary duty to keep these common areas safe? Can the owners who voted for this be sued? Probably not. Anybody can be sued in a lawsuit, but I don't think they're going to be held liable for, signing the petition on this. Okay, next. And also look at the cheat sheet on preventing crime and limiting liability. We have some great suggestions for you if your association is seeing an uptick in crime. And so I'd really encourage you to take a look at that. Next question. What would you think if you're the board treasurer and someone else closed a financial account without your knowledge? What would I think? I would think I would be mad because as the treasurer, you are responsible for, oversight of the finances. So you should have been consulted on that. Now, I don't know if that someone is the management company and maybe it was in the contract that after a certain period of time, after they took over as management company, you were switching to their bank. That process probably would be okay. But if it's a board member or the management company does it without any knowledge and there's no, justification or basis for it, I would be taking a second look at it and asking for why this happened and make sure that their expectations set for the future so it doesn't happen again. Sometimes, they're like a CD's up for renewal, right? And, we're just going to throw it right into another CD at the same rate. I wouldn't be upset about that because they're, helping your association. So if it's something like that, then I would not be upset about it. But I would ask for more information and ask for their feedback before you get upset. So you hear their side of the story. Okay, what does an HOA do when no one wants to serve on the board? I had this question twice last week, actually. A couple of things. Pump out information asking for people to be on the board. Okay, so send out letters, newsletters, please asking people to volunteer. If that doesn't work, try to pinpoint specific people, maybe that have come to the board on issues and have been reasonable. Pick up the phone, call them multiple times, see if they will volunteer. If that doesn't work, look to your committees. Do any committee members willing to step up and serve on the board? If that doesn't work, then reach out to our firm. We have a letter that we send to the owners letting them know that no one's willing to be on the board. The next step will be to have the court appoint a receiver to run the affairs of the association. This will be very expensive, at least $80,000 in receivership fees annually, and that will be passed on to all the homeowners in the form of a special assessment or an increase in the monthly assessment. I cannot think of one time that our firm has sent that letter where we didn't get a board member or board members to start running the board. So it's a very effective solution to get people to step up to help. Next question. What does an HOA do? What can a homeowner do if the association board fails to respond to a violation appeal within 10 days as allowed by the state statute. Okay, so I don't know specifically which statute you're referring to, but I'm guessing that you were sent a violation letter by your board, or somebody you know was sent a violation letter by your board, and then that person who received the violation letter wrote back to the board with a certified letter requesting certain information. And that's what triggers under Arizona law for the board to respond back with the information that's required to respond back to under the law, such as who witnessed the violation, what section in the CC&Rs was violated, what are the potential penalties or, repercussions of this violation, and what actions can the board take. And so if they didn't respond after that, what can you do? You can send a letter back saying, hey, cite this section in the statute that says, hey, you were supposed to respond to me and you didn't. Please respond. If they don't respond after that, you can file a lawsuit. You can go to the ADRE and file a complaint there. Arizona Department of Real Estate. There's a administrative law judge section that handles homeowner and association complaints. That's an option. One thing you want to think about, though, is that lots of times the initial violation letter already complied with that law, and that may be why the board is not responding. So maybe that initial letter already had all that information in there. If you're a board listening, we've got 75% of you here today are boards. If they send this certified letter, go ahead and send it again, the information, because you don't want to get into a fight about what the statute says. Or you could send a letter saying, we received your certified letter asking for this information. It was already provided in the initial demand letter. If you have any questions, please reach out to us to let us know. Try to resolve this amicably. This is not something that needs to turn into World War III. Okay, next question. After our annual meeting, our CC&Rs say we have to have a meeting to elect officers after the election at the annual. Does this need to be noticed as the meeting? Best practices would be to have in the annual meeting notice an indication that after the annual meeting is over, there will be a quick open board meeting to elect officers, or you can have a separate meeting after the annual meeting and do it quickly after the annual meeting. Notice it 48 hours in advance of the meeting. Just state that the purpose of this meeting is going to be to elect officers for, the 2023-24 year. But yes, it does need to be noticed, properly noticed, to be perfectly, legal under the open meeting law. Okay, question number 11, ratification of board unanimous email voting. What is the procedure to get board email voting ratified at an open board meeting? Okay, let's back up a little bit. I am not, as an attorney that practices in this area, I am not in favor of boards taking action by unanimous written consent. There are at least 2 administrative law cases in Arizona that say that this violates the open meeting law. So be really careful on relying on the Nonprofit Corporation Act to make decisions as a board by unanimous written consent. I think if challenged, it's not going to withstand a legal challenge based upon what the open meeting law says, saying that, any decision that anytime a majority of, the board is, a quorum of the board is meeting to discuss association business, it needs to be an open board meeting. This directly contradicts that. Having a meeting outside or making a decision outside of a board meeting by email to get around having an open board meeting, that's properly noticed. I think that violates the open meeting law. Even though the Nonprofit Corporation Act allows it, and most of our clients are nonprofit corporations, the open meeting law is more specific and trumps it. And there's 2 cases in Arizona by administrative law judges that support what I'm saying. When can you use email as a board to make decisions? In an emergency situation. The 48 hours notice is suspended under the open meeting law, and you can make decisions by email in a true emergency situation where you cannot wait 48 hours to make the decision. How do you ratify that decision after the emergency board meeting or the emergency board email vote? At the very next open board meeting, you read into the record what happened, what you did, and what was decided. And that is, sufficient. If you have an emergency board meeting and you don't give the 48 hours notice, you should take minutes. so that there's a reflection on that. If you're making decisions by email, you should keep those emails and then add all of those, either the emails or the minutes of the emergency board meeting, to the attachments for the minutes of the meeting where it's ratified. We have a great cheat sheet on open meeting law too, which our office has shared with you in the Zoom chat and then also on Facebook Live. Okay, next question. Regarding street regulation, can the special meeting the law requires for voting be as part of our annual meeting with a separate mail-out ballot? And is the quorum required the 1/10 as mentioned in our bylaws, or is it a simple majority of our members? So yes, you can, have that, vote as part of the annual meeting. No problem. You can use a separate mail-in ballot. You could even attach it on the main ballot. I'm going to need to have my office pull that statute just so I can look at the specifics on what the majority vote is, and then I'll come back to this question at the end. So that's going to be the new statute that was just passed. I'm going to need the actual statute language, not the summary that we did at the beginning of the class. Okay, and you should be able to find that in the Planned Communities Act very quickly from my team that's looking for it. Okay, question number 13. In a planned community that has private streets, does the Disabilities Act regarding parking and obstructing sidewalks apply? So yes, in a planned community, the Fair Housing Act would apply. The Americans with Disabilities Act typically does not apply because associations are typically not a place of public accommodation, but the Fair Housing Act does apply to associations. And so if an owner or a resident is parking in such a way that makes it difficult for handicapped residents to access the mailbox or to, be able to use the sidewalks, that could be considered a fair housing violation by the association, and the association needs to take action to make sure that that's not happening. Next question, number 14, jumping back to the new parking law. Are private roads in a gated community exempt from this new change? Yes. Number 15, regarding protected flags. Is flying a U.S. flag upside down protected? I think that's a violation of the federal flag code, and it would not be protected, but I would encourage you to just Google federal flag code. And I'm pretty sure it has to be flown in the proper manner. It has to be illuminated at night. So flying it upside down, I don't think is going to be allowed under Arizona law, because our law says you have to comply with the federal flag code when you're, flying the American flag. Okay, question number 16. Under the new law, does this mean, and this is the removal law, does this mean if one member is on a petition to be recalled and the board fails to call, notice, and conduct the removal meeting within 30 days, all board members are removed, or only the name on the recall petition? Under the language of the statute, it's all board members would be removed if they fail to comply with the newer sections in the removal statute and the Disabilities Act and the Planned Communities Act. Okay, next question. Let's see. Is any time or way the board meets subject to the open meeting law? Some boards have catch-up coffee times, agenda-setting conversations, informal gatherings. Are all of these subject to the open meeting law, such as providing 48 hours notice in advance of the meeting? Also, what are the notice requirements, if any, should the board members gather for holiday events, and these events are clearly social? Okay, so again, we're going to be sharing with you our cheat sheet on the open meeting law, because this does a deep dive on everything you need to know about the open meeting law in Arizona for board members. But the bottom line is here. Anytime a majority of the board or a quorum of the board is meeting to discuss association business, it's subject to the open meeting law, which means that you have to provide notice to the membership 48 hours in advance of the meeting and allow members to attend, listen, and participate if they choose. So is there any way around this? A workaround would be have less than a quorum of the board meeting to have coffee time, agenda setting conversations, informal gatherings. So if you have less than a quorum, it's not a board meeting. If you're having a social event, it's not a board meeting. If you're having a social event and a quorum of the board is discussing association business, you just crossed over in the meeting. So if you're at a social event, do not discuss association business, okay? Only meetings are the only time that you should be discussing association business with the quorum of the board. Okay, question number 18. Looks like we have a couple more questions that have been answered. So we have 28 questions now. In an HOA gated community with a restriction on street parking after 11 p.m., is it legally permissible for the community to allow parking after 11 p.m., specifically for holidays, without violating the Fair Housing Act? Or would they be required to extend this privilege to all holidays uniformly? Okay, so a couple of things here. So if your HOA it's gated, so this new law that we talked about earlier does not apply. If your association is gated and you have an on-street parking, no parking after 11 p.m., you really shouldn't be allowing parking after 11 p.m. It's, worded, no parking shall be allowed on the streets after 11 p.m., okay? It doesn't matter if it's a holiday. Of course, you can be flexible. Sometimes there are days of the year where, you might be having a party or something for a holiday. You can be flexible, but you don't have to be if you don't want to be as a board. I would err on the side of, not picketing people on Christmas Eve or Christmas Day, but they shouldn't be doing overnight parking, obviously, on the holidays. Is this a violation of the Fair Housing Act? No, the Fair Housing Act isn't, it doesn't extend. There's no protection for holidays under the Fair Housing Act that would allow you to violate the on-street parking rule. So that's not going to apply here. Okay, next question, 19. What evidence would be necessary to appeal to the state for violation of the open meeting law? What action could be taken by the state to require condo directors to comply with the open meeting law? Okay, a couple places where you can go. You can file a lawsuit in Superior Court asking for a mandatory permanent injunction compelling the board to comply with the open meeting law. That's one option. There's going to be some costs to do that because lawsuits can be expensive. But one avenue would be to file a lawsuit in Superior Court asking for an injunction compelling the board to comply. Another avenue, go to the Arizona Department of Real Estate website. Our office is sharing the link with you in the Zoom chat and also on Facebook Live. And basically, you fill out the paperwork with the Arizona Department of Real Estate for a complaint against the association. You have to pay a $500 filing fee, and they will assign this complaint to an administrative law judge, and there will be a hearing to decide whether or not there's been a violation of the open meeting law. Now, the administrative law judge is just going to say whether there has been a violation or hasn't. Okay, and then the board would have to pay the filing fee, the $500 filing fee, if it's found that they violated the open meeting law. But it doesn't make them comply going forward. It just says, yes, there was a violation. They did not comply with it. The only way you can make them to comply going forward is to go the Superior Court route and get an injunction compelling them to do that. Question number 20. Is there a legal requirement that board members enable their cameras during a video board meeting? How do members verify that the board members are present if their cameras and video is disabled or shut off and motions and seconds are conducted properly? I'm kind of laughing about this because I'm kind of a violator on this sometimes on my board meeting. So I guess I would say you're allowed to appear telephonically at a board meeting. Okay, I don't do it often, but let's say our board meeting's running late at 6:30 at night and I got to pick up one of my kids at Cross. Sometimes I'll say, hey guys, I need to go get one of my kids. I'm going to stay on the call on my phone, but I may need to go to, telephone only because it's dark in the car. I think as long as you're communicating why the reason is that you have the camera off, I think that's fine. It's best, of course, to have the camera on so everybody can see the board members. But I don't think there is a legal requirement that you have to have your cameras on because state law allows board members to appear telephonically at board meetings and you don't have to have the camera on. Okay, we also have a great cheat sheet on virtual meetings, which kind of covers some ins and outs of how to conduct virtual meetings that we're going to be sharing with you in the chat and on Facebook Live. Question 21, are HOA boards required to follow Robert's Rules of Order? We have received conflicting information on this. So unless your board bylaws require you, or your CC&Rs require you to follow Robert's Rules of Order, you do not have to follow Robert's Rules of Order. It's very unusual that I'll see that in the bylaws, and whenever I see it, I take it out anytime we're doing an amendment, because Robert's Rules of Order is extensive, and there's lots of ways you can violate it just by not, reading the 12 volumes of, parliamentary procedure to follow that. So we've got a great cheat sheet on board meetings, and in that cheat sheet we're sharing with you now, we talk a little bit about what parts of Robert's Rules of Order or parliamentary procedure you should adopt, because they're just good business practices. So I'd encourage you to take a look at that. Question number 22. If an association's articles allow a variable number of directors, odd numbers like from 3 to 7, what board process should a board take to change the current number? Well, first look at what your bylaws say, because it may say something like your board can be like anywhere between 3 and 7 board members. And, the way to change it is this. So make sure that the procedure isn't outlined in your bylaws. Most of the time it's not. So what you want to do is talk with your attorney and figure out how we're going to implement this. So, maybe you notice that you're going to do this at a regularly scheduled board meeting. You vote to increase the board, and then maybe at the next annual meeting, those 2 spots are open, and then they're elected, or maybe you're just appointing to fill those vacancies. So it's typically done, if it's not outlined in your bylaws, how to do it at a board meeting, and you should talk to your legal counsel about the best way to do it based upon your documents. Okay, question 23. I am a very active homeowner and know most of the other homeowners. Our board believes that electronic communication is sufficient. How can I convince them that many of our residents do want communication via paper and don't like electronic communication? We also have many full-time tenants that do not have access to the website, but who want to be involved, but they don't know about events. We have a close-knit community, but word of mouth is not always enough. People want the reminder on the fridge. Okay, great question. So this is kind of like a push and a pull between technology and paper, right? I think probably the best way to get the message to your board would be just start a little petition and have people sign it saying that in addition to the online or electronic communications, we also would really like to have paper communications. Now, this may be a cost thing. So, maybe the board doesn't want to pay the cost to mail things every week to people. Maybe if this is something that a lot of owners in your community want, maybe there can be a stack of papers in a central location at your association where anybody who wants the paper can, go to the mailbox and pick it up. Or maybe because you are very active and know a lot of homeowners, maybe you could offer to get the word out to people by handing it to them. I'm sure there's some sort of a resolution that can be reached here once the board understands that, okay, this many owners really want this. And the best way to do that would be to have a petition or a survey done by the owners and then take that information to the board. Okay, next question, number 24. When talking about a censure, what actual effect does a censure have? So, good question, picking up on that. It's a written documentation that this person is falling below the standard expected of a director in the community. And it's in the minutes. It could be used as evidence in the future if there's going to be a petition circulated to remove this director from office. It could be evidence that's used in a court of law if there's a lawsuit regarding behavior of the board member. But really, a censure alone doesn't do much. You're right. It's not like that ejects them from meetings or anything like that. No, it's just a written documentation that sets the stage to be used at some other time in the future. And it also puts the person on notice, hey, your behavior is unacceptable. We are documenting it in the meeting minutes, and we are keeping a paper trail now so that this behavior is documented so it doesn't continue. Okay, next question. Number 25, open meeting law's intent seems to be to ensure that boards are not having discussions and making decisions behind closed doors, like email. This normally limits boards to only discussing topics with a quorum in the board meetings. What could a board do to have discussions as a quorum outside of board meetings, like a public boardroom, Facebook page that's accessible to everyone, or just don't? I would probably say just don't. So if a quorum of the board is meeting, it really needs to be noticed and an open board meeting. If you less than a quorum can meet to discuss association business, but not a quorum unless you follow the open meeting law. Some of our clients have what they call board planning meetings, and no decisions are made at these meetings. So basically, it's the board puts out notice, hey, we're having a planning meeting, and it's a quorum of the board is going to be there, so we're giving you 48 hours notice. It's only going to be the board talking because there's no formal action going to be taken by the board. We're just discussing issues. And so that way the board doesn't get interrupted by the homeowners. Some boards like that. But be really careful. You do have to comply with the open meeting law, and that is probably one of the most prevalent things that associations get sued for. It's usually not the only thing, but it's an add-on and also they don't follow the open meeting law, and here's the proof. Okay, next question. Shall a management company make all accounting visible to the board treasurer? 100% yes. Number 27 out of 29 questions, because I'm going to return to that other question. Okay, our CC&R say that the board can acquire and convey real property except as that described as common elements under Arizona law 33-1212. Does this give the board authority to purchase property on behalf of the association? First, you got to look at your CC&Rs, which it looks like you've done, and it says that the board can acquire, buy, or convey, sell property, except that as described as common elements. So I guess yes, but this is kind of complicated because it sounds like you're a condominium. So you can't obviously sell your common elements because each owner owns a percentage interest in the common elements in a condominium. So can you buy property? I don't know what you would be buying property for. Maybe the adjacent, property is, like a vacant lot and you want to put pickleball or shuffleboard or tennis courts in there. I would say you definitely want to look at what your documents say. We want to look at what Arizona law says, and you want to get your attorney involved because you also want to know, hey, can we use our assessments for this purpose to buy it? So you may have the authority. It looks like you have the authority to buy land, but hey, can we use assessment money to buy the land? It may not allow you under the language of the CC&Rs to do that. So this is a complicated legal issue. You definitely want to get your attorney involved because you're going to need to integrate that property into the plat for your association. You're going to want to find a way to finance it, pay for it. And there's a lot of legal issues on this that you're going to need to run by your attorney. Okay, next question, number 28. We recently had our annual meeting and voted on an important issue. Some board members canceled important information from the membership. Is this legal? And if so, what action can be taken? This is kind of hard because I don't know what was canceled and I don't know what the important issue was. So it's hard for me to, comment on it. I have to expect that there was a reason. Maybe there was too much information and we only focused on the most important information that evening at the annual meeting or that afternoon at the annual meeting. I don't know. If you were withholding information from the membership intentionally to get the vote, that I would not agree with. So you want to, like I said, transparency is very important when you're serving on your board so that you build trust with your owners. And when you try to hide something or you give half information or half truths, it's going to come back to bite you and it's going to make a very dysfunctional association. Question number 29. Should the management company make all financial information available to all board members other than the treasurer or just the treasurer? So I'm a proponent of everybody getting everything. So in my association, we in our board packet every month, we get everything. We get a copy of the bank statements. We get the year-to-date budget. We get the financial statement. We get copies that the CDs are in existence and when they need to be renewed. We get everything. And I think that's smart because you may have a treasurer that's not that financially savvy or doesn't have a lot of financial experience. And so everybody on the board is accountable to make sure that everything's in order. The treasurer has a higher, heightened level of accountability, but the whole board is responsible for this. So, this comes up from time to time. When we see embezzlement in an association, it's typically when the board is in the dark and they don't know what's going on the finances. So be proactive. Ask the management company to provide this. They should have no problem providing this to you. One thing I want to warn you about is there's a delay usually. Like we always review last month's financials at this month's meeting. Okay, so you're not going to have everything real time, typically. Sometimes there's a delay. Okay, now I'm returning to this question. This is the last question for today. This is on the new legislation. To reread the question regarding street regulation, can the special meeting the law requires for voting be a part of our annual meeting? I said, yes, it can. And is the quorum required 1/10, as mentioned in our bylaws for the meeting where we vote on this, parking restriction or the roads, being able to maintain or keep, regulation of roads in our planned community? Or do we follow the quorum requirement of the bylaws, or is there a special quorum requirement under? Okay, so the statute number is 33-1818. And basically, again, just to refresh, because we've got a lot of questions on this today. So if you're a planned community and the declaration was recorded after December 31st, 2024, So there's a couple different ways that this law is written. So I think we need to back it out. So if you're a planned community, right, and the streets are owned by the city, town, municipality, or county, and your declaration is recorded after December 31st, 2014, and after the period of declarant control, the association cannot regulate any roadway for which the ownership has been dedicated to or is otherwise held by the governmental entity. Okay, so that's very important for you to hear. So if your association was, created after December 31st, 2014, and you're after the period of declarant control and the streets are owned by city, town, or municipality, the association has no authority and shall not regulate any roadway for which the ownership has been dedicated, okay? So now we look at the new law. So after December 31st, 2014, bam, you can't do that anymore if your CC&Rs are recorded. If we go back to what the new law says, and I hope that, I think maybe I may have misstated here when I talked about it early, so I'm glad we came back to this. So now the difference is it was recorded before. So if we go to the new law now that we just talked about, so again, after December 31st, 2014, you don't even need a vote anymore. This is what the law says. You cannot control parking or any sort of regulation of the roadway, okay, if the roads are owned by the city, town, or municipalities. After 2014, December 31st, 2014, can't regulate it no matter what. Before 2000, so if you have an association that's no longer under developer control, and the declaration was recorded before January 1st, 2015. And that regulates any roadway for which the ownership has been dedicated, right, to the governmental agency. Then here's what you follow. So any association before January 1st, 2015. So by June 30th, 2025, so before June 30th, 2025, the planned community has to call a meeting of the membership on whether or not to continue to regulate public roadways. If the number of owners voting at the meeting on the question is sufficient to constitute a quorum of the membership, so your 1/10 is okay, and a majority of that number of votes to continue regulating the public roadways in the planned community retains its authority to regulate the public roadways. And then the board has to, if that happens, so if you have the meeting, before June 30th, 2025, you have a quorum at that meeting, which for your association looks like it's 10% according to your bylaws, and the number of members at that meeting, and a majority of that number, majority of the quorum, whatever it is, how many people are there? Let's say you've got, 1,000 member association, and a quorum, if it's 10%, is going to be 100. And 51% of those 100 that count say that they want to retain authority to regulate those public roadways. Guess what? You can retain the public roadways. The association needs to record with the county recorder's office a document stating that they're going to continue to regulate the public roadways. If it fails, and the community either doesn't hold a vote before June 30th, 2025, or it fails at that meeting that you don't get a majority of the quorum, then you no longer will be able to regulate the public roadways, and the existing regulations and the CC&Rs will expire. And again, it doesn't apply to one-way streets, and it doesn't apply to any privately owned roadways. So this is a really confusing law. So if your CC&Rs are recorded after December 31st, 2014, and your planned community, publicly owned streets, you cannot regulate on-street parking. Okay. If you're one of those associations that had CC&Rs that were recorded before January 1st, 2015, and your planned community and streets are, dedicated to the city, town, municipalities, counties, you have to go through this voting process. Okay. And if it passes, you record it with the recorder's office. If it doesn't pass, you lose the right to enforce it. I think the writing's on the wall here, right? I already kind of said this in my presentation. The writing is on the wall that this is going to be difficult to get this vote, if not impossible. So, and the writing was on the wall several years ago when the first part of the law was passed, saying any CC&Rs after December 31st, 2014 that are recorded, you can't regulate anymore. So I think we know the trend here is that on city-owned streets, government entity-owned streets, county-owned streets, it's not going to be likely that HOAs are going to be able to enforce parking restrictions, going forward. Well, let's finish up here. A few things to mention. We had 119 live viewers on Zoom and many others on Facebook Live today. So thank you so much for making an effort to be here today. Don't forget, we have our December events coming up. In December, we do not, due to the holidays, have a third Tuesday in December neighborhood services HOA class with the topic like we did today. Instead, what we do is we have our first Friday. And we do that normally, as you know, the first Friday of every month at 9 a.m. We hop online and Zoom and Facebook Live, and we answer questions for free of charge. So in December, it's like a huge event because we take our normal neighborhood services HOA Academy classes and we combine it with First Fridays, and we answer a lot of questions. I think last year we had 50 plus questions. So it's going to be a great opportunity for everybody to get their questions answered for free. And that is going to be on Friday, December 1st at 9 a.m. And it's going to be our firm's virtual First Friday event and class number 12 of our virtual HOA Condo Academy. But the class is going to be limited to just answering questions that are submitted for the class. Also in this class, we're going to give you a little bonus information. We're going to provide tips for keeping communities festive and safe this holiday season. And we'll wrap up 2023 with our lengthy question and answer session, where we answer every question you may have that your association may have over the past year. As you know, we teach these classes pretty frequently. We're doing it once a month, and then we hold our First Fridays once a month as well. Please consider leaving our firm a Google review. It's really important that we receive feedback from you as to how we're doing, what type of classes you'd like to see, and we provide that information to the different neighborhood services departments so that they can show it to their supervisors and their city councils to let them know that the classes are needed and wanted. So I really encourage you, if you have time today, to please leave our firm a Google review so that we can then share the information with the neighborhood services departments, with the different cities around the valley, because we're starting to plan our classes for 2024. If you check out our website, we already have the first 6 months of classes listed on our upcoming classes seminars tab. And we always welcome feedback so we can improve. And we're going to be sharing a link, if we haven't already, in the chat on how to leave a Google review. Again, it's really helpful for us to hear from you. We are always happy to get the feedback so we can continue to improve. Okay, last but not least, happy Thanksgiving to all of you and your families. It's certainly my pleasure to work with the different neighborhood services departments around the Valley to provide this free education. I love getting the questions and hearing from all of you, and thank you so much for caring about your communities and wanting to make them better, spending time to learn. And also thank you to my entire staff, especially Morgan, Calista, and Jen, for everything you do to help make these classes be successful. I appreciate you and very thankful for you. So happy Thanksgiving, everybody. I will see you again on December 1st. Take care.